Hello, viewers. This is attorney Naresham Gehi, and today's show is live. And we'll be speaking about a very important issue. But before we speak about this important issue, it's critically important for us to see what's happening today. And there's some great news from the world of immigration for H1B visa holders. A judge in California has ruled that Trump's power to supersede the laws will not be acceptable, which means that the changes with the Trump administration was trying to bring about in connection with the high wages for H1B visa holders has been stopped for the time being by Judge White from California. This is a big victory. So, folks, this is a big issue because if you all know, a while ago, we had some issues from the Trump administration wherein the Trump administration was saying that the highly skilled worker category under the H1B visa holder should be restricted, especially because of COVID. And people who want to employ H1B workers should be paying a very, very high salary. The judge said that without a proper system that includes a proper public comment and a proper rational reasoning behind this issue, the Trump administration cannot do that, thanks to the American Manufacturers Association and other plaintiffs who stood up against the administration. And they also said that the Trump administration cannot just rush things and get them done. So this is a very good ruling for H1B visa holders. So the issue in the past was about H1B holders who were going to pay, who had to pay, wherein the employers had to pay very high salaries in order to qualify them. So, for example, if you're a systems analyst and if the prevailing wages were on 65 or 70,000, the administration wanted them to pay a salary of 120,000. So, in a way, it was a diplomatic way for the administration to stop the H1B visa program. So, excellent ruling coming from California by Judge White. And I commend the judge for this fantastic ruling. So today's important show, today's topic is very important for our viewers. And this is about what can you do if you have a deportation order against you? What can you do if you have a removal order against you? Can you still qualify for a green card? So this is a question that has been asked over a period of time. And so today we are going to make sure that we answer questions for our viewers who had questions, especially about, what can they do if they have a deportation order? So let's break this problem down and let's talk slowly about the subject. And let's talk about the most common reasons why people get a deportation order. You came into this country and you entered by crossing the border, or you entered with a legal entry into this country. And then the most common thing that happens is people apply for political asylum. And after you applied for political asylum, you got your work permit. After you got your work permit, you are very happy. But finally, you went before an immigration judge. And the judge said, I am sorry, I cannot grant you a green card. I cannot approve you for permanent residence. And now you have been ordered deported from the United States. You have been ordered removed from the United States. So you have a choice that you can either take voluntary departure, which means that you can voluntarily leave this country under Section 240, under Section 240, 240 of the Immigration and Nationality Act. You can seek an order of voluntary departure, or I am going to order you deported or removed from the United States of America. So now you got a deportation order. This happens when you appear before the judge, or this can happen when you fail to appear before the immigration judge. And in this case, after you got the deportation order, you might have either appealed the case or you sat quietly in America and you're lucky enough not to be picked up and deported at that time. So now you have an outstanding order of deportation. So the most common misconception is that if you have an order of deportation, you cannot do anything in future. That is incorrect. You may have choices. You may still have choices. So take an example. If you have been ordered deported from the country, and if you're still living here, and you were single at that time, when you got a deportation order, you were single. Suddenly you met somebody over here, and that person may be a US citizen, or that person may be a green card holder. So in either of these cases, let me repeat here, you have an order of deportation, you are single, and even if you marry a green card holder or a US citizen, you should consider the provisional waiver. I'm going to talk about what the provisional waiver is. So you got married now, and now you are telling your wife or your husband that I have this problem, that I want to get my green card, but the problem is that I have an outstanding order of removal. So what you need to do is, of course, these cases are very complicated, and you will have to speak to a good immigration lawyer. So the lawyer needs to understand the case. The lawyer can be situated anywhere in America. Even if you are in New York, you can hire a lawyer from California. Immigration law allows you to do that. You hired the lawyer. And now what the lawyer can do, he can do two things. And unfortunately, the first strategy is not working a whole lot. He can file a motion to reopen if you legally entered into the country. And if the motion gets approved, if it gets reopened, excellent for you. And if you're married to a citizen, then the judge may grant you a green card here. But the chances for the motion are very less. But there's another second bite of the apple here. You have one more bite of the apple. You can consider the provisional waiver. And that is absolutely excellent. That's the best choice right now. So what happens with the provisional waiver is, after you get married, you have to get the alien relative petition approved. After that is approved, you will have to file the waiver of deportability. You will also need to file the waiver of unlawful presence. Needless to say, at the same time, you will have to do the NVC processing of the case. Then after that, your interview will be scheduled before the consulate. It is very important for you. It is very important for you to make sure that you put your best foot forward in working hard on the waiver. You need to do your best on the waiver. And as I mentioned, if you have an outstanding order of removal, or even if you had an order of voluntary departure, You will need these waivers. And if both these waivers are approved, which is commonly referred to as the waiver of deportability, and if the other waiver is approved, which is known as the waiver of unlawful presence, then the good news for you is, that what you can do in these cases is you will have to travel outside the country. And if you do not have any other negative factors, and if your case is cleaned up, the good news is you may still qualify for a green card. So we took the first example based upon a person who came here and he applied for political asylum, or he was here on a student visa and he went before the judge and he got an order of deportation. So to make a long story short, even if you have an order of deportation against you, there may be light at the end of the tunnel. There may be light at the end of the tunnel. So it is critically important for you to make sure that you know your legal rights. And remember, having a deportation order may not be that it's the end of your case. You may have light at the end of the tunnel. Now let's take another example. You have a deportation order against you, and your parents in the United States, your parents are green card holders, or they are United States citizens. Do you know you still have hope? Yes, you do. In this case also, you may be eligible for the provisional waiver depending upon the facts and circumstances of your case. So take an example. You applied for political asylum, or you came to the country and you were caught at the border, and after that you were ordered deported by the judge, or you did not appear for the hearing. But now your parents in this country, either your mother or your father, happen to be green card holders, or they happen to be citizens. So in this case also, what you can actually do is ask your parents to apply for you. After your parents have applied for your case, after the relative petition gets approved, start working on the waiver of deportability and the waiver of unlawful presence. Of course, that's a lot of work. It'll be difficult for you to do it on your own. You will definitely, I would strongly recommend you to get a lawyer, because, proving hardship is not an easy job, and immigration can become difficult, especially when you do not, prove the hardship properly in those cases. So then, in this case, your parents have applied for you. After that, your relative petition was approved. Now you applied for both the waivers. It is very important for you to make sure that both the waivers are approved. So you'll have to show that here I am, I came to this country either on a student visa and the judge ordered me deported, applied for asylum, I have a deportation order, I entered the country, the immigration officer asked me to go before the judge, I did not appear, I have a deportation order. And now my mother or my father are green card holders and they are sponsoring me. They can sponsor you, yes, and then you'll have to get both the waivers approved, which is known as the professional waiver, as well as the waiver of deportability. And if that is approved, then you will have to travel outside the country. People ask me this question, Mr. Gehi, don't you think that the consular officer is going to stop me? if both your waivers are approved and if there are no other adverse factors in your case, I don't think it to be a problem. So the next question is that, Mr. Gehi, have you handled a case wherein your client left the country after getting those waivers approved and he came back? Yes, I have handled those cases. And did he come back? The answer is yes. Prior results do not guarantee future outcome. The answer is yes, I've had clients who come back happily. So you should not be scared if your waivers are approved and if there are no adverse factors in your case. But it is very important for you to work with any competent attorney who is very experienced in waivers, because having that right experience in waivers can be a turning point in your case. So keep those factors in mind, especially when you are applying for a waiver of deportability, or if you are applying for the provisional waiver. So there is good news. Let us sum this up very easily, that you have a deportation order or you have an order of voluntary departure. And if your spouse is a green card holder or a citizen, or your parent is a green card holder or a citizen, you may be eligible for a provisional waiver and a waiver of deportability. And if those two get approved, and if there are no adverse factors, and if the consulate approves your case, the good news is that you can still get your green card even if you have an outstanding order of removal. So folks, this is Attorney Naresham Gehi. If you have any questions, feel free to reach our website at www.gehilaw.com. You can email us at info@gehilaw.com, or you can call us at 718-263-5999 for a free initial personal consultation. We have 3 offices in New York, and we handle immigration cases from all over the United States and the world. The instant program is an attorney advertisement. Prior results do not guarantee future outcome. We will be back again with our viewers with some more information from the world of law. Keep watching this program brought to you by Gehi Associates. Don't forget to share this video. Green Card with Gehi will be back with you again next Wednesday, same time, same place. Thank you for watching, and don't forget to share this video.